Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the basics of the IRS Audit Reconsideration. An IRS Audit Reconsideration is a great opportunity for some taxpayers who may qualify. A lot of practitioners don't know about the Audit Reconsideration or just assume it can't be done, but that's not true. We've had a lot of success with it in the past. Generally what happens is taxpayer is audited, right? And then the taxpayer disagrees with the outcome of the audit, right? Taxpayer goes to the audit, gets a notice of examination changes. They're absurd. They're not founded in reality. Taxpayer tries to reason with the agent or examiner. Agent or examiner won't budge. Taxpayer may qualify for an IRS audit reconsideration. There are certain times in which the audit reconsideration can be used. Here are some of the common examples. One, the taxpayer did not appear. Now, that doesn't necessarily mean the taxpayer got notice and then just decided they didn't want to appear. In a situation we had several years ago, taxpayer had a fraudulent preparer. Fraudulent preparer said they were going to appear, and then they didn't. And in another example that we had, the fraudulent preparer was the power of attorney and never told the taxpayer that there was even an audit, so the taxpayer couldn't appear. Another common situation is there are some additional facts that after the audit's completed. Typically, it requires that the taxpayer couldn't have accessed these facts beforehand. Not always, but typically it can't be that that the taxpayer is hiding the facts and then is like, well, depending on how the audit turns out based on some of the facts, then I'll divulge the rest of the facts later in an audit reconsideration situation. In addition, it could just be much later down the road and certain rights have fallen by the wayside or they've already been used up, and taxpayer disagrees with the audit, has the opportunity to pursue an audit reconsideration, or at least may be able to qualify for the audit reconsideration. A few common questions we get about the audit reconsideration process is as follows. Is there a time limit in order for a person to apply for an IRS audit reconsideration? The answer is no. There's no specific statute, no specific time limit that says, okay, after 18 months you can't do it. But the idea is payment is still due. Right, the IRS is still pursuing it in some fashion, and so if the taxpayer makes payment, it could negate the ability to pursue an audit reconsideration. Form 12661 is not required, but it's recommended for the taxpayer to provide the information to the IRS as to why an audit reconsideration should be considered, and the information necessary to show that they may have facts to substantiate their position. Typically, the taxpayer is going to need documentation to support the request as well. Without that documentation, the IRS agents don't have to even consider it. And let me tell you, if you don't have any documentation to support it, chances are the IRS agents are not going to give it its due time. If you're out of compliance for prior years and are hoping just to avoid getting into this mess in the first place, oftentimes what a taxpayer can do is enter into one of the amnesty programs, whether it's domestic income, foreign income. There's many different programs available. There's General Voluntary Disclosure Program, now referred to as VDP. There's Offshore Disclosure, which includes the streamlined programs, reasonable cause, and delinquency procedures. We have lots of information available on our main websites, and we have different sub-websites depending on the specific topic of interest. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.